can now take your seat. And these are the second rounds of our Moot court, our Moot competitions. And it's Team Bravo against Team Alpha. Team Bravo being the applicant in this matter who are sitting on my far left. And then Team Alpha, the respondent in this matter, who are sitting on my right.
May it please this honorable court, Madam President, Your Excellencies. My name is Makombero Mova, and I am joined by co-agent Charmaine.
Council, just to confirm which you are. Alpha Bravo.
Team Bravo. Thank you, Excellency. Now stating that I am joined by co-agent Charmaine Bailey.
Just when you're giving us the names just go slowly because we need to do it.
Thank you.
So this is Team Bravo.
Yes, Excellency. Thank you. So my name is Makombero Moropa, and I am joined by co-agent Charmaine Bailey and Nathan Zindikilana. Yes. Moropa. I am joined by Charmaine Bailey to my left.
Charmaine.
Bailey. And Nathan Zindikilana. Nathan Zindikilana. And finally, Kunisoro Sige, who is our off counsel. Together, we are the agents for the applicant.
I don't know about masks. I think you should have your masks on.
Not for you.
Thank you, Your Excellency. Together, we are the agents for the applicants in the matter between the Forum for Women with Disabilities Forward versus the Republic of Iran. Now, our reason for being here before this honorable court follows the several futile attempts that the applicant made at seeking redress for women with disabilities and children with albinism in the justice system of Iran. Your Excellencies, the applicant's intentions are clear. These are to defend the rights of persons with disabilities where domestic laws and institutions offer no vindication. Because at the end of the day, persons with disabilities are not shadows of an undesired demographic. They are people as well. Thus, the overarching submission of the applicant is that the respondent violated the international human rights of women with disabilities and children with albinism, and arguments for this notion will be made in the following manner. Firstly, Charmaine Bui will address the preliminary issues of jurisdiction, locus standi, and admissibility. Secondly, I will rise to address claim 1 and 2 before your honorable court. And thirdly, Nathan Zindikilana will rise to address claim 3 and proffer our prayer before this honorable court. With the leave of this court, these will be the opening remarks on behalf of the court.
If it pleases this honorable court, my name is Ryan Stotombe. Ryan, R-Y-A-N. And my co-counsel to my immediate left is Ntandenko Simoyo. And to my extreme left is Tanyara Zotuiskara. And together we are appearing for the respondent in this matter. And we are Team Alpha. In the next 35 minutes, this is how we propose to structure our submissions before this court. Firstly, I shall address this Honorable Court on the preliminary issues, that is jurisdiction and admissibility, and on the first claim for 14 minutes. Thereafter, my co-counsel, Tandeko Simolo, will address this court on the second claim for 10 minutes. Thereafter, my co-counsel, Tanyana Zadreskawa, will conclude our submissions by addressing this court on the third claim for 6 minutes.
I'm sure about the time coming.
Yes,
We look at our clocks and after 15 minutes,
indeed, we clear the time, Honorable Justice. And before I hand over the mic to the applicant, I just want to bring to the attention of this court practice direction number 8 of the practice directions of this court, which makes it clear that whenever we are addressing the judges of this bench, we address them as honorable justices. I know that my learned friends across the bar, they refer to the judges of this court as Your Excellencies.
so it doesn't matter. If you call me a kid or a dog, I'll be mad.
Thank you.
May it please the court, honorable judges, Charmaine Beery is my name, and I arise as counsel for the applicant in the matter of Forum for Women with Disabilities versus the Republic of Parano. I shall make submissions on the preliminary matters for which I will discuss admissibility, jurisdiction, and standing. Now, honorable judges, we submit that this court has the necessary jurisdiction to hear this matter. The Republic of Parano in 2018 became party to the protocol to the African Charter on the establishment of the African Court. The respondent state also deposited a declaration under Article 34, Sub-Article 6 of the protocol, and in doing so, consented to the jurisdiction of this court. In addition to that, honorable judges, we submit that this court has subject matter jurisdiction as these claims are concerned with the interpretation of rights as well as the enforcement of obligations that arise from key international human rights treaties such as the Convention on the Elimination of All Forms of Discrimination Against Women. Honorable judges, we submit further that the test of locus standi as outlined in Article 5, Sub-Article 3 of the African Charter has been complied with, as forward is a non-governmental organization which has observer status and therefore has capacity to bring this claim before this court. With regard to admissibility, Article 56, Sub-Article 5 of the African Charter provides that communications shall be considered if they are sent after the exhaustion of all local remedies, unless the procedure of exhausting local remedies is unnecessarily prolonged. Now, we submit that this requirement has been complied with. I shall draw the attention of this court to the case of Jawara versus the Gambia, when it was noted that in making a determination of whether or not local remedies have been exhausted, regard must be had to the availability, effectiveness, and sufficiency of such a remedy. Now, a remedy is available if it can be pursued without impediment. It is sufficient if it is capable of redressing the complaint, and it is effective if it offers prospect of success. Now, Your Excellencies, in establishing that these three requirements have been complied with, we shall offer two arguments. That forwards is unable to make an appeal to the Constitutional Court due to impediments caused by, firstly, the general attitude of the respondent state and society in protecting persons with disability, and secondly, the procedural requirements that do not reflect prevailing state practice. Now, with regards to the first point, we note that over the years, the respondent state has shown great apathy and ineptitudeness towards respecting, promoting, and fulfilling the rights of persons with disability, and this is tantamount to a disregard of the spirit and letter of the Convention on the Rights of Persons with Disability. This is shown, Your Excellencies, by the views of the Minister of Home Affairs and Minister of Trade in paragraph 23 of the facts, It is shown by the difficulties encountered by women and girls with disabilities as outlined by paragraph 10 of the text, and this is also shown by the questionable integrity of the justice system of Parano as outlined by paragraph 23 of the text. Now, Your Excellencies, in Dorvik versus Croatia, the European Commission on Human Rights noted that in assessing the effectiveness of a remedy, regard must be had to the prevailing legal and political climate. We submit in light of that the remedies have been exhausted in this regard, as appealing to the Constitutional Court of Parano has its various impediments that render this application unavailable. We also submit that state practice, as reflected in the case of Attorney General versus Unity Dole in Botswana, as well as Telesol Zimbabwe versus Portras in Zimbabwe, show that states should not unnecessarily be bound by procedural requirements to the extent that justice does not prevail. The strict adherence to procedure on the part of the respondent, without considering the precarious position of the applicant and their vulnerability, is contrary to state practice and ultimately constitutes a hindrance to obtaining an effective remedy. Regard must be had to the vulnerability of disabled persons in determining whether or not a remedy is realistic, and this was outlined in the paragraph 37 of Prohit and Anaga versus the Gambia. We therefore submit.
Before we proceed, the facts of the case show that the respondent is not deposited instruments relating to the protocol to the African Charter on Women and People's Rights on the rights of persons with disabilities in Africa. Would that have an impact on the jurisdiction of this court?
No, Your Excellencies, we rely in our submission on the African Charter, and the rights are arising daily. And with that, as well as the fact that the respondent state has made its party to the protocol on the establishment of the African Court on Human Rights, and that Article 3 of that protocol states that this court has jurisdiction when matters of interpretation of international law have been submitted before it, that this court indeed has jurisdiction to entertain this matter.
In further, if we look at Article 3 of the protocol to the jurisdiction of this court, it is stated that application of the Charter and then this protocol and any other relevant human rights instruments ratified by the states concerned. So, what is your understanding of any other relevant human rights instruments? Because it seems to us that it's very, very broad.
Your Excellencies, it is our contention that any other relevant instruments ratified that consist of violations that speak to violations of rights that have been indeed violated in this case are relevant and may be applied by the court. Any relevant international law instrument which the respondent state has ratified is necessary in determination of whether or not the respondent state is liable in this instance.
Does that not cause confusion? Because we've got so many human rights instruments in the world. Some are more binding than others.
Not necessarily confusion, Your Excellencies, but we do submit that it is very important and necessary that there be various international law instruments that deal with disability, and thus promoting the aspect of human rights itself. And this court, in accordance with the principle of lex specialis, is specifically enabled to deal with violations of international law rights in this case. We therefore submit, Your Excellencies, that strict adherence to procedure in this instance is an impediment, and a remedy which cannot be pursued without an impediment is as good as no remedy at all.
So we are saying that we are at liberty to look at all, because all these international human rights instruments, if you look at them, they are underpinned by equality, non-discrimination, even though they may touch on different subject matters. So are we as a court to go in the dark to say this is applicable, this is not applicable, and if there are inconsistencies within those instruments, what is your take on that?
Your Excellencies, we are not citing all international law instruments. For purposes of this application, we rely on the Convention on the Elimination of Discrimination Against Disabled Persons, as well as the Convention on the Elimination of all forms of discrimination against women, among others. We are not citing all international law instruments. We are citing those that are relevant to the particular violations of human rights that have been done in this case. These impediments, Your Excellencies, stand in the way of vindicating the applicant's claims before this court, and pursuing them is a futile attempt. Having established admissibility, jurisdiction, and locus standi, we submit that the applicant is rightly before this court. And having said that, I shall defer proceedings to co-counsel who will deal with the first and second claim.
May it please this honorable court, I rise to address claim 1 and 2 before the excellencies. Now, in light of the above claims, Makombere Muroka. With your permission, I will begin by giving an outline of our arguments, and then I'll proceed to offer our submissions before this honorable court. Now, in light of claim 1, the applicant argues that the removal of women with disabilities and children with albinism from their homes, placing them into institutional care, and attending schools in the temporary shelters that are meant for learners with albinism only, violated international human rights law. To justify this, we will offer two sub-arguments before this honorable court. Firstly, the removal of children with albinism from their homes denies them the right to enjoy parental care and protection. Secondly, the institutionalization of women with disabilities amounts to a discrimination, as it denies them access to their sexual and reproductive rights, together with family benefits. In light of claim 2, applicants will proffer two main arguments. Firstly, that the failure by the respondent to bring the killing and mutilation of persons with disabilities to a halt violated Schmidt's right to health. The second main argument is that the failure to put in place good practices on access to justice violated Muller's right to access justice. With your leave, I'll proceed to address claim 1. Firstly, the removal of children with albinism from their homes denies them the right to enjoy parental care and protection. Now, the removal of rights and welfare of the child. Article 25 of the African Children's Charter further stipulates that children are not supposed to be separated from their parents, and in keeping with Article 19, it states that every child has the right to reside with his or her parents and enjoy the parental care and protection thereof. This is not the case in the present matter because the ethnic and linguistic background of these children is in question because of their removal from their original homes. The respondent is therefore in violation of Articles 19 and 25 on the basis of this particular removal. Now, the respondent may be inclined to argue that it is in the best interest of the children to remove them from their homes since there is no adequate protection within the society. But such an argument cannot stand, and as it is not in the best interest of the children to remove them from their parents at a young and tender age. Paragraph 21 of the Act mentions that children below the ages of 10 were taken in and were transferred into shelters which did not have a family setting for their upbringing. In the case of Midwell versus Midwell, it was held that the separation of children from their parents will make them suffer psychologically and emotionally, therefore causing them irreparable loss and damage. Once removed from parents, it is commonplace that children feel neglected and unloved, even though children below the ages of 5 were indeed allowed to be accompanied by their parents. The other age groups over the ages of 5 were of course denied this particular right, and therefore the respondent left many children exposed and in need of parental protection. The respondent also violated Article 23, paragraph 3 of the Convention on the Rights of Persons with Disabilities, which advocates for the respect of the family and the home. It is provided that children with disabilities shall have equal rights with regards to the enjoyment of the family life, and they are not supposed to be neglected or segregated on the basis of these disabilities. In the present matter, children with albinism were separated from their parents because of their particular disability of albinism. The respondent cannot rely on the principle of necessity in this case in support of such a removal because the measure was indeed unreasonable. The respondent did not consider the long-term effects on the children in question, such as the loss of a normal childhood or the disturbance of a parent-child relationship. The applicant submit that.
Counsel, I want to understand your argument. Now, you seem to concede that the placement into these camps was to protect the children. Am I correct?
Yes, Your Excellency.
Now, so perhaps let me ask you, do you argue that there is a hierarchy of rights, or do you argue that all rights are equal? And in situations where perhaps rights are not equal, what do you propose where there is a conflict in rights themselves?
Your Excellency, rights in this question are of course in the main contention here, that the right to life being protected by the state seems to be the right that the state is, that the Republic of Peruano is stating to be the right which should be given the greatest regard. But in this case, because all rights of course can be limited, in this case, the Republic of Peruano should also take into account that all these rights should be enjoyed inclusively. Now, it is not the applicant's contention that the right to life only should be regarded as the most fundamental right for these people, but all these rights should work in sync so that these children can have and be afforded the adequate rights for their upbringing.
So are you then saying that rights are hierarchical?
Your Excellency, rights indeed are hierarchical in the sense that the right to life is given precedence, but in this case it can be limited and of course must be subject to the inclusion of other rights. Now, the removal of the children without blessing from their homes violated their rights to parental care and protection, as has already been mentioned. The respondent, in its violation of Article 23 of the Convention on the Rights of Persons with Disabilities, cannot rely on the principle of necessity, given that this measure was indeed unreasonable. The respondent did not consider the long-term effects, as we have already mentioned, of this detention or this removal from their original homes, and that it could have on the cognitive development of these children. Secondly, the institutionalization of women with disabilities is discriminatory, as it denies them access to their sexual and reproductive rights, together with family benefits. The institutionalization denied women with disabilities and children with albinism access to their sexual reproductive rights and family benefits, respectively. Article 18, paragraph 1 of the African Charter gives full statutory recognition of the sacrosanctity of the family unit as the basis of society. The applicant admits that society is only as strong as its families, and to break down this unit by separation is tantamount to tearing the great fabric that makes up society. Paragraph 21, once again.
So, what is the understanding of family if a mother is with their child? Isn't that a family?
Yes, Your Excellency. Now, to the exclusion of other children who did not receive parental guidance and protection within these camps, of course, are the ones who should be afforded this right. And this was denied them in the process of placing them within the institution. Now, paragraph 2 of the fact makes it clear that men with disabilities, as well as husbands of women with disabilities, were not taken into protective care units. The discrimination here is twofold. It is the blanket approach used by the respondent and the length of time of the institutionalization of these persons being indefinite. Now, the applicant submits that the announcement by the government to say that women and children have peculiar vulnerabilities is not disputed, but it is for this very reason that the government should have included the entire family unit to be brought in together so as to shield the vulnerability if it had to be sanctioned in that way. The Convention on the Elimination of All Forms of Discrimination Against Women in Article 13A and C provide for state parties to take all appropriate measures to eliminate discrimination against women in other areas of economic and social life in order to ensure, on a basis of equality between men and women, the same rights. Now, in this case.
Before you proceed, what we seem to be getting from this rights discourse is that the state is obliged to do something, but it's not a one-way street. There are rights and responsibilities. What are the women with albinism doing to actually ensure that the situation is improved?
Thank you, Your Excellency. Now, we know that the applicant understands that the society that the women with disabilities are living in is tantamount to the violation themselves because the state is not fulfilling its obligation. But women in this case are also taking care of their children in the best way possible available to them, and taking into account the fact that the state in this case is noted to have no economic power of its own in the fact that it does not have enough money to take care of certain obligations. The state and the women with disabilities are doing the best that they can within their available resources to them to do the best they can to protect their families. And therefore, the removal of children or the placement of these women with disabilities into institutionalization violates or impedes on their ability to take care of these families or even their children or any other counterpart with such disability. Now, the right to family benefits is indeed outlined within the Convention on the Elimination of All Forms of Discrimination Against Women in Article 13A and C.
But we may never know if women and children alone is not even protected from violence, given that the statistics show that intimate partner relationship is where the most violence occurs. So, if as a mother and you are taken away from an abusive husband, doesn't that save you in some way?
Yes, Your Excellency, it does save these women, but in particular now the fact that all persons or women with disabilities in this case were taken into this particular facility without taking into account their individual situations, therefore violates the right to sexual and reproductive rights. And this is the applicant.
Yes, given also the statistics show that women with disabilities, any form of disabilities, are more vulnerable to violence. So wasn't the state right in actually offering them double protection to these women?
Yes, Your Excellency, the state's intention may have been right, but of course the exclusion of other rights in the protection of one right then amounts to a violation of international human rights law. Rights should be enjoyed in the best way possible and should be afforded to all people. And of course, the taking of all persons with disabilities in this case should of course not impede on the fact that other people are enjoying such rights and disabilities are numerous, and of course they should take into account that other persons may not have been vulnerable than others. Now, the right to life, of course, and equality is inextricably linked. When assessing the right to life and its protection by the state, they should also take into account that the quality of life should also be taken into account. And therefore, the applicant makes the submission that the rights to sexual and reproductive rights and reproductive health should be taken into account. Moving on to claim 2, Your Excellency, the applicant will make the following two main arguments as stated in our outline. Firstly, the failure by the respondents to bring the killing and mutilation of persons with disabilities to a halt violated Schmidt's rights to health. The applicant submits that the respondent violated Articles 12 and 16 of the Convention on the Elimination of All Forms of Discrimination Against Women, which obligates state parties to ensure access to healthcare services, including those relating to family planning, and mentions appropriate services in connection with pregnancy and the right to decide. The general right to the highest attainable standard of health is protected in Article 12 of the International Covenant on Economic, Social, and Cultural Rights. Paragraph 12 of the facts notes the horrific event of September 2014 when Schmidt, a minor who had cerebral palsy, she was kidnapped and mercilessly raped and was left bleeding in a maize field near her home. As if this was not perilous enough, she was denied medical care due to her disability. Now, General Comment 14 of the International Covenant on Economic, Social, and Cultural Rights sets forth that right to health is not simply a right to be healthy, but rather a robust human right extending not only to access to healthcare services, but also to the underlying determinants of health. Schmidt was in an emergency situation, and international human rights law recognizes the universal obligations placed on health institutions and their personnel to accept individuals who are in an emergency, and this was not done in the case. This was also reiterated in the case of the Zimbabwe Human Rights NGO Forum versus Zimbabwe in 2006. Lastly, Your Excellency, the second main argument is that the failure to put in place good practices on access to justice violated Mula's right to access justice. Mula's right to access justice was violated in that she was given an unskilled and unqualified special educator who had a duty to adequately narrate her plight, but failed to do so on numerous occasions, and this is noted in paragraph 11. Given these arguments, Your Excellency, we believe that the respondent violated international human rights law in this regard. I will now defer proceedings to my colleague.
Before you do that, don't run away from this practice. Now, before you do that, the High Court, in their ruling, they say that the actions of individuals should not be attributed to the state, but the state has put in measures to bring those who violate rights to, to account. What's your response to that?
Your Excellency, I will bring the court's attention to the case of the Zimbabwe Human Rights NGO Forum versus Zimbabwe in 2006, where the court held that human rights standards not merely limit the authority of state organs, but they also impose positive obligations on states to prevent and sanction private violations of human rights. The implication of this is that international human rights law can be invoked to protect citizens or individuals under their jurisdiction from the harmful acts of others. And in this case, it is impossible to attribute such actions on behalf of the state where such negligence arises. With the leave of this court, I will now defer proceedings to my co-agent. Yes, Your Excellency.
On the first claim, do I understand your argument that institutionalization is proper? It's actually a derogatory or a non-derogatory right, but you are more concerned with how to attack.
Your Excellency, we will make two answers with regards to that. The first position is that this institutionalization violated the rights of women with disabilities and children with albinism for the very reason that was mentioned within the Pro-Hit case, Pro-Hit versus the Gambia case, where it said that indefinite institutionalization is indeed discrimination. Second, the applicant also went further to extend that even within the institutionalization, and even if it was indeed sanctioned by law in an applicable way and in the interest of other rights should take precedence and other rights should also be taken into account when this institutionalization happens. Therefore, these are the two arguments that the applicant is making before this honorable court.
In your answer to the question asked by my sister there, on the issue of state and functionaries, you are saying that individuals are vicariously liable for those things.
Your Excellency, now in the mention of the case that we mentioned earlier with regards to the attribution of obligations on state for persons who are not part of the state, this can be of course defended under international human rights law, because the state people should not be able to find recourse by doing things that affect the rights of others and claim that they do not have to answer to any tribunal or any other law that may impede on such actions. Therefore, such case will give effect to the fact that even the state can receive obligations and liability for actions of private persons when negligence exists, or even in a state where these people should have been defended by one recourse or another. Thank you, Excellency. I will now defer proceedings to my colleague.
May it please this court, Madam President, Your Excellencies. My name is Nathan Zindikelani, and I shall be addressing this court on Claim 3 of the applicant. In this claim, we shall argue that genetic testing of the OCA gene is a violation of international human rights law. In making this argument, we shall proffer two sub-arguments. The first being that genetic testing is a violation and an impediment and an impairment of the rights of disabled persons to equality and non-discrimination. Secondly, we shall argue that genetic testing is a violation of the right of disabled persons to inherent dignity and to be treated with the highest and an equal view in society as their counterparts who do not suffer or do not have these conditions. With the leave of the court, I shall continue. Your Excellencies, regarding our first submission, the applicant submits to this court that the genetic testing, Your Excellencies, the applicant submits to this court that genetic testing of OCA constitutes a violation of the right to equality and non-discrimination that is extended to persons with disabilities under Article 5 of the Convention on the Rights of Persons with Disabilities. Your Excellencies, the applicant further argues that this must not be considered in isolation. The applicant invites this court to take consideration of Article 31 of the Vienna Convention on the Law of Treaties, which states that in interpreting treaties, courts or individuals must take regard of the object and purpose of the treaty. In this sense, we say that this court must take regard of the object and the purpose of the Convention on the Rights of Persons with Disabilities, which is outlined and stated in the preamble of the Convention and in Article 3, which states the general principles, which we cite here for persuasive value. We submit that these principles are three. The first being inclusion, the second being non-discrimination, and the third being the acceptance that persons with disability and that disability is a natural and acceptable stage of human diversity. With this in mind, Your Excellencies, and in light of this, we submit before this court that there is a nexus between genetic testing and its contribution to the discrimination of persons with disability. And we say that this occurs in the following ways. Your Excellencies, paragraphs 17 and 18 of the facts show that there is a prevalent and an existing pattern of discrimination against persons with disabilities. It proves that there has been and exposes that there has been mutilations, killings, and abductions that result and amount to persecution on behalf of these individuals. In light of this, Your Excellencies, we argue that genetic testing, Your Excellencies, sidelines and that it places a limelight on a condition that is already looked down upon in society and creates a situation where these individuals are further looked down upon as a result of stigma, misconception, and primitive beliefs.
Counsel, the rights you advocate for, clarify for us. Is it the right of the pregnant woman or the unborn child or both?
Your Excellencies, the applicant does not contest the intention or the purpose of the respondent in providing this service, as they have argued that it is to extend sexual reproductive health rights. What we contest is the negative effects it has. In this sense, one being the message that is conveyed, which is to say that individuals with albinism are not similar with individuals that do not carry the OCA gene, and that therefore they should be treated and viewed equally. Secondly, we argue that there is a reasonably foreseeable harm of discrimination arising from this genetic testing, because it goes on to tell individuals that have been participating in this mutilation, in these killings and these abductions, that what they believe and the way they've acted is accurate. And we argue, Your Excellencies, that this results in discrimination.
No, we get that. My question is, are you advocating for the right of the pregnant women who are undergoing the testing, or for the unborn child, or for both?
My apologies, Your Excellencies. We are advocating for the rights of both. Your Excellencies, we move forward to establish discrimination using two aspects of law. The first we would rely on, and we will invite the court to take consideration of Article 2 of the Convention on the Rights of Persons with Disabilities, which gives the definition of what discrimination on the basis of a disability is. According to Article 2 of this convention, discrimination on the basis of disability occurs when there is a distinction that has the effect of impairing the enjoyment and exercise of fundamental human rights and freedoms to persons with disabilities on an equal footing with others. In addition, this consideration, a case that does have persuasive value, but did set out the test for discrimination, which is the case of Hudson versus Lane, decided before the Constitutional Court of South Africa. In the case of Hudson, they were set aside two tests for discrimination. We will focus on the first. The court set out and the court adjudged that there is discrimination when there is a distinction based on a specified ground. And we submit before this court that disability is specified as a discriminable ground under Article 2 of the African Charter, Your Excellencies. In light of this, Your Excellencies, we submit, Your Excellencies, that genetic testing does indeed violate the right to non-discrimination and equality. I shall move on to our second sub-argument.
It says that this is not forced. If you look at paragraph 24, the government may provide free genetic testing to allow women to know pregnant women to know whether or not they're going to gene which causes OCA, and then they can make informed reproductive decisions. It's like the corona COVID vaccination. Governments all over you're telling us get vaccinated, but they're not forcing. Where does the discrimination lie?
Your Excellencies, we agree with you that this was optional and that there was consent. But we are not challenging the procedures itself, but we're challenging the prejudicial effect. And we are asking this court to take a balance of the risk and the purpose. If the purpose is to extend sexual reproductive health to persons with disabilities, but if the result as a risk is the discrimination or the violation of the right to human dignity of persons with disability, then we submit before this court that the court ought to take in favor of the violation of the right, Your Excellencies. Moving on to our second sub-argument. The applicant submits that the genetic testing of OCA constitutes and contributes to a violation of the right to human dignity that is extended to persons with disabilities. We submit that Article 5 of the African Charter extends and provides for these protections, that all persons have inherent human dignity. We further submit that Article 17 of the Convention on the Rights of Persons with Disability sets out clearly that all persons have the right to mental and physical integrity. And we submit that the right to mental and physical integrity and the right to human dignity are intertwined. Your Excellencies, we proceed to further submit that the measure at hand is the inherent value of a human being. And a scholar, Hugo Grotius, in his writings, put forward, and we cite him for persuasive value, that the inherent value of humans is divided into two aspects, intrinsic and extrinsic. Extrinsic has to do with how an individual is viewed by others, and intrinsic with how an individual views themselves. And we argue that genetic testing, in creating this discrimination, creates an environment where individuals living with the OCA gene or conditions of the OCA gene look down upon themselves or feel less relevant, and where other individuals in society extrinsically look down upon these individuals and, in effect, view them as second-class citizens. Your Excellencies, in light of my time, I will move on to address our prayer with the leave of the court. Your Excellencies, the applicant provides the following prayer. The applicant submits that the removal of women with disabilities and children with albinism from their home, placing them into institutional care, and attending schools in the temporary shelters that are meant for learners with albinism only, is indeed a violation of international human rights law. We further submit that the failure to bring the killing and mutilation of persons with disabilities to a halt, and the failure to put in place good practices on access to justice, is in violation of Smith's right to health and life and Moore's right to the access of justice. And we further argue that the genetic testing of OCA does indeed constitute a violation of international human rights law. With this, Your Excellency, the applicant is the case.
So what is what do you want? Just like coming to court and saying this one looked at me with a strange eye, so if we find that there's been a violation, what do you want the court to do?
Your Excellencies, the applicant requires and is asking this court to make an order that will put forward that these claims that we have made are indeed violations of international humanitarian law.
Then after that,
And after that, Your
after
Excellency,
that, the applicant will the women concerned and the children concerned.
Your Excellency, with the leave of this court, I would wish to confer with pro-counsel. I thank Your Excellencies for the patience. The applicant then submits that the force of a declaration under international law is to the effect that states will act in accordance with the restrictions, with the declaration that has been given, and act in accordance to ensure that what has been declared is taken into account. And failure to do so would have the consequences of violation of international law. Thank you, Excellencies.
Just a minute, Council.
As introduced earlier, Honorable Justices, my name is Ryan Stotombe, and I'll be responding directly to the applicant's case on jurisdiction, admissibility, and on the first claim. With regards to jurisdiction, Honorable Justices, I submit that Rule 29 of the rules of this court stipulates that this court shall deal with cases and all disputes concerning the interpretation and application of the protocol on the African Charter and the African Charter on the Rights and Welfare of the Child, the African Charter on Human and People's Rights, and other protocols or human rights instruments ratified by the state concerned. If we look at the facts before us, Honorable Justices, particularly paragraph 3 of the facts, it makes it clear that the respondent state has not ratified the African Charter on Human and People's Rights on the rights of persons with disabilities. Therefore, I submit that this Honorable Court does not have jurisdiction to entertain any interpretation or application of this instrument. I shall proceed to the material jurisdiction of this court, based on Article 3. No, I mean paragraph 3 of the facts. Paragraph 3 of the facts, it makes it clear that the state of Pirano has not deposited instruments relating to the protocol to the African Charter on Human and People's Rights. So in terms of Rule 29 of the rules of this court, it makes it clear that this court can only hear a matter it makes it clear that this court can only hear a matter wherein the interpretation and application of the charter the protocol and human rights instrument has been ratified by the state concerned.
If you look at Article 3 of the protocol to this court, it talks about application of the charter, this protocol, and any other relevant human rights instrument ratified by the state concerned. Indeed, my dear Honorable Justice. So what is your comment on that?
My comment on that is that this state, it cannot entertain this protocol since the respondent state is not a party to it. Because for this court to be able to deal with the protocol, the respondent state must be a party. And in this case, we are not a party to this protocol. So it is irrelevant in this proceedings.
Yes, proceed.
With regards to the temporal jurisdiction of this honorable court, I submit that paragraph 4 of the facts is not clear. Paragraph 4 of the facts is not clear when the respondent state became a party to the protocol to the African Charter on Human Rights, on Human and People's Rights, on the establishment of this court. If we look at the facts before us, Honorable Justices, it is clear that the cause of action in this matter, it arose in September 2014. Therefore, we submit that if the declaration was deposited in 2014 before the month, if the declaration was deposited after 2014 September, we submit that this court does not have jurisdiction to hear this matter. But if it was deposited before September 2014, we concede to the jurisdiction of the court. I shall proceed to address this court on admissibility. In terms of Rule 50, Sub-Rule 2, Paragraph F of the rules of this court, the applicant ought to, in terms of Rule 50, Sub-Rule 2, Paragraph F of the rules of this court, it stipulates that any application that has been brought before this court, it must comply with the requirements provided in the rules. In the case of Law Society of Zimbabwe versus Zimbabwe, the commission stipulated that whenever an issue before the court is, whenever an issue is brought before the court,
So you said Law Society versus?
Law Society of Zimbabwe versus Zimbabwe. it was stated that the conditions that are provided in Rule 50, Sub-Rule 2, are conjunctive. In the event that one condition is not satisfied, it follows that the matter is inadmissible. In this particular case, I submit that the respondent state, the applicant, has not complied with the requirement of exhaustion of local remedies. In the case of African Commission versus Kenya, this court stated that this rule is mandatory. If we are to consider the facts before this honorable court, it is clear that there is a remedy that was available before the domestic courts. Paragraph 29 of the facts, honorable justices, makes it clear that there was a remedy available in the constitutional court. Since the matter before the High Court on its own, it involved the violations and enforcement of human rights. Therefore, I submit that in terms of paragraph 29 of the fact, there was a remedy that was available. In the case of Mzarengwa versus Zimbabwe, the commission stated that a court, when considering the requirement of exhaustion of local remedies, it must determine whether the remedies available at domestic level were capable of addressing the issues that are being raised substantively. If we look at the facts that we have, honorable justices, it is clear that the Constitutional Court was capable of addressing the issues that are being raised by the applicant on the substantive issues. They were specifically told, honorable justices, to comply with the domestic procedure and thereafter come to the Constitutional Court so that the Constitutional Court can then deal with the substantive issues that they've brought before this honorable court today.
So, Council, if it was impossible for them to exhaust domestic remedies, surely we would have expected them to comply. If you look at the facts, there were so many hindrances to the applicant actually coming to before the local courts. So when we look at in the realm of international human rights instruments and the spirit behind those instruments, surely can you say that the applicant is wrong in approaching this court?
In response to your question, honorable justice, I shall make two submissions. The first submission is the requirement of exhaustion of local remedies before this honorable court is mandatory. It ought to be complied with. Secondly, I shall refer this honorable court to the case of Mazerengwa versus Zimbabwe. The commission in that case made it clear that domestic procedures, they ought to be complied with. They can only be dispensed with only if it has been proven that the domestic procedure is unjust or prolonged. In this case, honorable justices, we had no argument from the applicants that the domestic procedure of authorization is unjust or prolonged. And in any event, honorable justice, the domestic procedure of authorization, it is meant to align the interests of the applicant and the interests of the victims. And therefore,
how do you get authorization when people are not engaged regarding?
Okay, in response to your question, honorable justice, I'll make reference to the facts. If we look at paragraph 11 of the facts, it is clear from this paragraph that Mula was above the age of 14. If we then go to paragraph 21, the facts are also clear that only children under the age of 10 were in protective institutions. Therefore, they ought to have gone and obtained authorization since Mula was not in protective units. We then move on to Shimta. The facts are also clear that she was above the age of 16. And then that after she was denied the right, allegedly denied the right to medical help, she went home. Although she is now deceased, they ought to have gone to obtain authorization from the legal guardian, as it is common cause that a child does not have legal capacity to consent.
Even when she was dead.
they ought to have obtained authorization from the legal guardian, because even if she was alive, she was not going to be the one who was going to provide the authorization. The authorization was going to be provided by the legal guardian, as the facts show that she went home. Then on the last part, Honorable Justice, I'll refer you to paragraph 28. There is no evidence at all that they were denied authorization. In the case of Mtikila versus Tanzania, this honorable court made it clear that it cannot rely on a result that is unknown. In this case, it was not established at all. The applicant was just hesitant to attempt to obtain authorization from protective institutions. Therefore, without any evidence, the applicant's case falls away. Therefore, I submit before this honorable court that the matter is admissible for lack of compliance with Rule 50, Sub-Rule 6 of the rules of this court. I shall proceed to address you on the second preliminary issue. The second preliminary issue is that there was inordinate delay to file this application. Paragraph 27 of the facts makes it clear that the appeal was lodged in 2018, and this matter was brought before this honorable court in 2021. The decisions of the commission, they have made it clear that any period that is beyond 22 months is unreasonable. This application was brought beyond 22 months, and therefore it is inadmissible before this honorable court.
If it is unreasonable, does it mean automatically inadmissible?
It follows, Honorable Justice, it follows. Since the case of Law Society of Zimbabwe versus Tanzania made it clear that failure to comply, it renders the matter inadmissible. I shall proceed to deal with the first claim. Before I go any further, I want to divide my response into two. Firstly, on the rights of children and the rights of women. A reading of Article 4 of the African Charter on the Rights and Welfare of the Child, it makes it clear that in any matter that involves children, the best interest of the child is paramount. This is also reinforced in Article 3 of the CRC. This court, in the case of AFDP versus Mali, it made it clear that the interests of the child are superior. Therefore, the issue as it relates to children before this honorable court is the decision to put children in protective units, the best interest of the child. To respond to that question, Honorable Justice, I would like to make reference to a decision by this honorable court in the case of African Commission versus Kenya. In this case, this court said the right to life is the cornerstone on which the realization of all other rights depends on. The deprivation of someone's life amounts to elimination of the very holder of these rights. This position is also reinforced in General Comment number 4 by the African Commission. As my learned friend as co-counsel, as the applicant said, he concedes that placement of children is to protect them. Therefore, in light of this decision of this court, it is clear that the placement of children in protective units is meant to protect the children and to safeguard their right to life, which is paramount. Therefore, without any evidence from the applicant that establishes that it was not in the best interest of the child to put children in protective places, it follows, Honorable Justices, that this case ought to be dismissed on this claim.
So, Counsel, are you saying the right to life is superior to all other rights? Because if you look at institutionalization, it means people are denied their right to freedom of movement, they might be denied their right to privacy. So is the right to life paramount, or is it superior to all other rights?
My response to that question, Honorable Justice, is if we look at General Comment number 4 by the African Commission, it was made clear that the right to life is the fulcrum of all other rights. What this means, Honorable Justice, is without the right to life, all these other rights that we're talking about before this court today, they cannot be realized. And basing on the decision of this court, the right to life, it precedes other rights.
Counsel, you have relied quite extensively on some decisions of the African Commission. If you could just tell us what is the value of decisions of the African Commission in this court?
In response to your question, Honorable Justice, I would like to make reference to the last paragraph of the preamble to the protocol on the establishment of this court. It makes it clear that the Commission and the court, they complement each other. Therefore, their decisions are only of persuasive value. Then moving on to the rights of women. I submit that taking women into protective units, as considered by the applicant, is meant to protect these women who are vulnerable, particularly their right to life. By doing so, the respondent state was just honoring its obligations in terms of Article 4, Sub-Article 2 of the Protocol of the African Charter on the Rights of Women. It makes it clear that the respondent state, a state has an obligation to eliminate all forms of violence that pose a threat to the right to life. In this case, the facts are clear. I shall refer to paragraph. Maybe if I may just confer with my learned friend on the paragraph. If we look at paragraph 10, Honorable Justices, it makes it clear that women and girls with disabilities in Pirano face high risk of sexual violence. And then also, if we look at paragraph 18 of the fact, the second from last statement, paragraph 18 of the fact, it makes it clear that persons with disabilities in Pirano, particularly women and children with disabilities, were abductions, killings, and mutilations. Therefore, protective units were meant to safeguard the fulcrum of all other rights, the right to life, which has been recognized by this court and the Commission as the foundational right. Therefore, I submit that the applicant has not made a case in respect of the first claim.
Also, if you look at the definition of discrimination on the basis of disability and rehabilitation, that is in the protocol setting up the schools, it seems to us that the practices of the respondent were really discriminatory, and all these moves that the respondent did do not even fall under the definition of rehabilitation. What would be your comment?
May I confer with my co-counsels? In response to your question, Honorable Justice, I would like to bring to your attention paragraph 17 of the facts. The reason why these children and women have been institutionalized is not because we intend to discriminate them, but it was because of the stereotypes that existed. Therefore, our intention, as considered by the applicant, was to protect the children, was to protect the women. And also, I'll draw your attention to paragraph 21 of the facts. It also shows that the intention was to protect the children and women, as these places are made clear that these are protective care institutions. Men were left out merely because they were not vulnerable as women. Therefore, there is no discrimination in this case. Unless directed otherwise, I shall hand over.
So I understand you to be saying that it violates their rights, it is intended to protect them, then it can be like if you look on the Convention of the Women's Rights, which says that the states have a duty to afford men and women the same rights, that law regarding their movement and children choose their rights.
Okay, in response to your question, Honorable Justice, I would like to make it clear that at law, rights are not absolute. Rights, they can be limited. The right to life is non-derogable. The right to life is above other rights, as indicated by the decision of this court. Unless directed otherwise, I shall defer proceedings to my co-counsel who will address you on the second case.
Thank you. Honorable Justices, I would love to take this moment, if it pleases this Honorable Court, to continue from the same sentiments that I feel that this Honorable panel has been insisting on when it came to the speech by my first speaker. For clarity, in Tando Yenkosi Moyo. May I proceed, please? Thank you. The protection of the right to life, esteemed panel, is the most paramount right in the human rights litigation or human rights instruments. The legal foundation for that has in a plethora of cases that the first speaker in Respondent has highlighted to this Honorable Court. The Inter-American Court on Human Rights in the case of Rodriguez versus Honduras, it stated that the margin of appreciation of the state takes precedence in situations where the protection of the right to life is in question. When you look at the facts of this question on a esteemed panel, particularly paragraph 17, it states that the reasons for the killing has been superstitious beliefs. We all know what superstitious beliefs are, the way people think. Because of the exigencies of this situation and the context in which this violation was occurring, the institutionalization of children with albinism and women with disabilities was there to give fulfillment to the right to life. Without the right to life, there is no right to enjoyment of parental care and the right to family. When you conceive on that point, therefore you will see that the acts done by the respondent states were there to give effect to it. Allow me to connect the argument to the rebuttal, to the point that was raised by the applicant. When it stated that the
superstition should actually be a ground for justifying discrimination.
On that virtue, Madam, I would love to direct you on the case of Moat versus Hansen. It was provided for and reported in 2006 in the African Human Rights Law Report. It stated that differential treatment doesn't necessarily mean discrimination or unfair conduct. Discrimination and unfair is only given effect to the context in which a means by a state is promulgated. The means by the state in this case were promulgated in order to safeguard the interests of people with disabilities. According to paragraph 12 of the facts, it clearly states that people with disabilities, they face an inordinate threat to their lives. This is not the same threat faced by every other person. Therefore, it is our argument as the respondent that to institutionalize them was there to give effect in the protection of their rights. I love to reference to the example that was given by the Honorable Judge in Zimbabwe, for example, this COVID pandemic. Because of the right to life and the threat that existed, there was a suspension and limitation of the right to movement and every other right. However, the reason why that was reasonable was because of what the state wanted to achieve. And what the state wanted to achieve was the protection of life. As it stands right now, more than 250 million have lost their lives. Therefore, because of this threat that was this threat that was evident in the facts, and that cannot be unquestionable, the means of the state were there to safeguard human rights.
Can we get what it comes for? Decisions are based on superstition. Some of us are dark skinned, so it might be like, oh, dark skinned women are witches. Superstition and very institutionalized because of that.
I do concede to that point, Honorable Justice. However, the argument was, the reason why I brought up superstitious belief, it was so that to elucidate on the threat to life that exists in the state. Because this is a third world country, according to paragraph 8 of the facts, the major population of the state of Perano is dwelling in rural areas. Therefore, the stereotype, Honorable Justice, is prevalent in the state. Therefore, it was the state's prerogative to protect the right to life. And allow me to draw also the fact in paragraph 17, that the right to life is not only protected, Honorable Justice, through the institutionalization. However, there has been investigation, and there's been investigation and the jailing of people that have violated this right. Allow me to confer on the exact paragraph to this case. Yes, that will be paragraph 19. So therefore, the state of Perano is not only institutionalizing them, but then it is also bringing those that are found guilty to justice. It was only through those means that the state felt like, because the cause is stereotypical, let us use a different approach. Let us not only investigate, but then while we're investigating, let's provide and protect the life that we still have. If you were to allow me to move over, Honorable Justice, to the argument, to the rebuttal of the right to health. Thank you. It seems that the applicants before this honorable panel cherry-picked part of the case of the Zimbabwe Human Rights NGO versus Zimbabwe in order to give effect to the unbased argument that they brought before this honorable court. What I love with the esteemed panel is that you brought the question to say, draw the link between the actions of private citizens and liability of the state. In that case, the full interpretation of that case provided that only when there's a nexus between actions of a private individual and the state, therefore on that basis you can have the state liable. It is our argument in this case that the actions by the nurse in paragraph 14 do not in any way fall upon the state being liable for that. If only the private hospital disapproved and impeded Shnita from access into it to get treatment. Therefore, on that policy, one could concede that maybe the state is liable. However, Shnita got into the hospital. After getting into the hospital, she was given care. Only when this nurse in charge, because of the stereotypical beliefs that they have, Honorable Council or esteemed panel, refused to handle and give help. Therefore, if we were to use the equation of the applicant, it would mean that every country is responsible for a human violation, as long as someone in that country is a stereotypical Indian. But that is not reasonable. It is only when the acts of the state are given effect to it that we find a respondent state liable. Furthermore, according to the case of Amnesty International versus Sudan, it stated that this liability of the state can be in two parts, either the violation of a positive obligation or the violation of a negative obligation. It is our submission as the respondent state before this panel that after such violation and after the report that had been filed by Forum for Women with Disabilities, the state went on to investigate, it went on to convict, it went on to raise these institutions. Therefore, the state was alive to the fact that it had responsibilities before international law. It is then our submissions in rebuttal that it's not as if as the respondent we're here to say that violations of human rights are condoned and they're right. Absolutely not. We know that the right to life is sacrosanct. We know that equality of people with disabilities is unquestionable. However, what we dispute and that the applicant has failed to prove before this honorable panel is the connection between the act in question and the responsibility of the state. This would be my rebuttals. Unless I would be of further assistance to this esteemed panel, I would rather defer proceedings to the third speaker.
Council, can you comment on the international principle of responsibility to protect? by the state. Because when we look at the actions of these people, the nurses' actions led to the death of Shinta, and with this minister who appeared saying something else. Doesn't the state internationally or under human rights have the responsibility to protect its citizens?
Most indebted. In the Zimbabwe human rights NGO case that I cited for persuasive value before this honorable court, I would first concede that yes, a state has responsibility to protect. In the facts, therefore, Madam Judge, it is clear that the state took actions. The question, therefore, before this esteemed panel is, were the actions adequate? According to Article 2 of the CRPT, it provides for the definition of reasonable. It provides for the definition of reasonable accommodation. One of the limitations for reasonable accommodation, Madam President, is the basis that it should not put on a state disproportionate, excuse me, let me read it verbatim, that it should not impose an obligation that is disproportionate or an undue burden. It is our submission that according to paragraph 6 of the facts, it is clear that the respondent state is a struggling state, Madam President. The economy is bad. Maybe also to convince you, in 2016, in the month of March, there was a meeting in Geneva in the United Nations where all the world countries attended to address the reasons for violations. And in one of the conclusions of that meeting, it stated that usually human rights violations are in tandem with the economic situations of a country. This is the reason why we do not have most first world countries before this panel, because they have the funds. It is our submissions that we pray before this honorable court that with the little resources that we have had, we have tried to protect the right to life. Therefore, this is why we have institutionalized them, not only permanently, but then to do so while we are investigating. And only after we have investigated and found those people liable, and only when it is safe, it is our duty to then bring them back to reintegrate them. That would be my answer. Unless any other questions arise, I'll direct to the third speaker. Thank you.
Honorable Justices, may it please this honorable court. As stated earlier by my colleague who spoke before me, my name is Tanyara Joyce Gala. Appearing as counsel for the respondent in the matter between the Forum for Women with Disabilities versus the Republic of Iran. And for the remaining minutes, I will directly respond to the submissions that were made by the applicant in respect to claim 3. And with the leave of the court, I'll proceed to my submissions. The applicant raised the issue of violation of inherent dignity and equal treatment of people living with disabilities. And may I draw the court's attention to Article 14 of the Protocol to the African Charter on Human and People's Rights on the Right of Women in Africa, particularly sub-Article 1, paragraph 8. And it says, state parties shall ensure that the rights to the health of women, including sexual and reproductive health, is respected and promoted. This includes the right to control their fertility, the right to decide whether to have children and the number of children and the spacing of children. Honorable Justices, they are being awarded their rights, and therefore this is not a violation of inherent dignity that is imputed to them. They are not being segregated on the basis of being disabled. This is shown in paragraph 24 of the facts, which says that the government is promoting genetic testing for OCA in order for the women to make their own reproductive decisions. All women. That is respect to every woman, either disabled or not. This is all.
Counsel. My understanding of the claim is that it is not the right to choose to have children that is being protected. Rather, the state is perpetuating discrimination against those who are differently abled by taking specific measures that put them on a spotlight and perpetuates discrimination that they face in society every day. So, do you persist to the argument that this is the same as the general protection of, sexual rights?
Most invasive. May I confer with co-counsel? Honorable Justice, may you please repeat your question?
Right. Now, you have argued that this is part of protection of a woman's sexual rights, the right to choose when and when not to have children. But the argument from the applicants or their claim is no, this is not a general right, but this is a specific type of child, one who is differently able. And the fact that that is being put on the spotlight perpetuates the discrimination that already exists in society about those who are differently able.
Most indebted. May I draw the court's attention to paragraph 14 of the fact, and it shows that there was a report that found that 1 in every 3,000 women in Perano have OCA. And also there was a report that established the prevalence of OCA. Also, may I draw the court's attention to paragraph 20 in terms of reports. My lady, we are putting in the limelight that we want to know the statistics that have to do with people with OCA. Why? We need to offer sunscreens, we need to offer services, as is shown in paragraph 20 of the fact that we are aiding in the full realization of the right to health by giving them sunscreens and by giving them lotions. Why? Because we would have noted the statistics of those that are affected with OCA, and therefore we are not putting in direct light of the people that are differently able, but rather we are making known so that provisions may be made to those that are differently able. If I may proceed with my submission. May I please have an additional 5 minutes? I know that my time is up.
3 minutes.
Thank you. On the right to inherent dignity and equal treatment. This is buttressed in the case of APDF and IHRDA versus the Republic of Mali, in which the court observed that having ratified the Maputo Protocol, the Children's Charter, and CEDAW, Mali was expected to abide by the provisions of these treaties, and regardless of the situation and sentiments shared. Therefore, the court chose this case to reaffirm the importance of safeguarding the rights of women and children, as is being done by the state of Iran. Furthermore, I draw the court's attention to paragraph 25 of the facts. And this goes in line with the issues raised by the applicant, where they stated that the object and purpose of the CRPD is based on non-discrimination. We also agree with this, and particularly raise up the preamble of the CRPD in paragraph 8, which clearly states that discrimination against a person on the basis of disability is a violation of the inherent dignity and worth of the human being. This is why, honorable justices, the tests are not only being carried on women who are already living with albinism, but rather it is being carried out on every pregnant woman, because there is need to find out if they have the genes or they can pass on the genes to their future children. Therefore, there is no discrimination in that every pregnant woman, who is an adult, is being called to the test. We are not separating between those already suffering with albinism and those who are not living with albinism. Furthermore, paragraph 25 of the fact clearly states that the genetic testing will be done on adults and it is not being forced. Thus, this then brings us to the doctrine of informed consent, which is in tandem and ethos with the human rights law. Informed consent is a process of getting permission from conducting a healthcare intervention of a person. And in order for a person to give informed consent, they should have 1, full realization of the facts, and 2, they should have adequate faculties in order to make a decision. And therefore, getting informed consent from these people who are being tested, it shows that we are not discriminating or segregating, but rather they are all seen in their legal standing as adults and they are being awarded their rights.
Council, it seems that the respondent is merely providing free genetic testing, and then only after that, these women are then supposed to make their own reproductive decisions. But is it informed consent based on, first and foremost, full disclosure of all pertinent information, so that even before they are tested, we know exactly what they are being tested for. But it seems they're just saying we are testing you for purpose of you making an informed decision, but without even initially informing them about what exactly is happening.
Most indebted, my lady, may I direct the Honorable Bench to paragraph 24 of the facts. These tests are only offered to adults and are promoted through radio announcements. These radio announcements provide for the information that is needed for them to know what the test is about.
Well, it doesn't say, it seems they are just saying on radio, they are announcing, come for free genetic testing, come for free genetic testing without a basis. Because before consent, I'm supposed to know the pros and the cons of even getting tested. And then, once I get tested, then I can exercise my options.
Most indebted, my lady, may I confer with co-counsel. Most indebted, my lady, this shall be our response. Already in paragraph 14, it is shown that there was a report that was published by the applicant, and it has the statistics of the OCA information, and they already stated that 1 in every 3,000 people in Perano have OCA, and the report also established the prevalence and every information that is relevant in order for them to know what they are dealing with. And therefore, genetic testing in this matter has been explained from long back if we give reference to paragraph 14 of the facts.
Isn't that an assumption, Council? Because a report is just a report. Was it disseminated? And given the fact that also women, especially women with disabilities, the disabilities come in all forms. We don't know whether the report was reduced into braille, with those who, whether the sign language was also used to interpret it to women with disabilities. So we don't know enough. Because when you look at the paragraph 21, it seems what was being promoted was the testing, not the information. In paragraph 24, the tests are only offered and are promoted through radio. So it's the tests that we promoted, isn't it? Not the information.
We are making a reasonable assumption then based on the report that was proffered by the applicant themselves. Carrying on from the doctrine of informed consent, it shows that seeking consent clearly shows that the respondent has respect for the individual as a person, and they are also respecting Article 5 of the African Charter on Human and People's Rights, which states that every individual shall have the right to the respect and dignity inherent in a human being. Furthermore, genetic testing will lead to a full realization of the right to health, and therefore it is not a violation. May I draw the attention of the court to paragraph 20, in which 2016, the government of Peru responded to the report that was made by the applicant and offered optometric services and sunscreen lotions for free of charge. And this shows that this genetic testing will aid the respondent as they would have been, as they plan in providing for their citizens, since the respondent has a duty to its citizens. Because of time, may I proffer our prayer before this honorable court. it is in light of these arguments that the respondent prays that the matter be dismissed on the preliminaries and also on its merits. We rest our case.
May it please this honorable court, I rise again to proffer the rebuttal on behalf of the applicant within the ambit of our 5 minutes. Now, I'll begin by addressing the points that have been raised by the first speaker for the respondent. The first speaker for the respondent noted Rule 29 of the statute of the court relating to the interpretation of the treaty of the, in this case, the African Charter. But the respondent erred in this assertion because we did not state the protocol to the African Charter on the rights of persons with disabilities in Africa, because the applicant is fully aware that no instrument was deposited with regards to this particular protocol. But the applicant mentioned the protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, which is mentioned in paragraph 4. Now, the respondent therefore erred in making this assertion. In any case, the case of Legal Resource Foundation versus Zambia noted that international treaties which are not part of domestic law may not be directly enforceable in national courts, but can nonetheless impose obligations on state parties at an international level. Now, also, the applicant cited other relevant treaties such as the Convention on the Rights of Persons with Disabilities, the African Charter, as well as the Convention on the Elimination of All Forms of Discrimination Against Women, which,
How do you impose an obligation on a state which has made it very clear that they do not wish to associate themselves with a particular treaty or convention?
Thank you, Excellency. Now, with regard to a state that has merely signed but has not yet ratified the document, in keeping with the Vienna Convention on the Law of Treaties in Article 31, it states that the states, in the interpretation of any treaty, it should take into account the spirit and the letter. And also, Article 18 of the Vienna Convention on the Law of Treaties states that even when a state has signed but is not ratified, it should not act in a manner that defeats the spirit and the letter of that particular convention. Now, the applicant also noted the...
Is there anything in your argument that speaks perhaps to international customary law?
Thank you, Excellency. Now, international customary law is created with state practice as well as opinion areas. And of course, in this case, because the applicant has only relied on treaty law, in this case, the Convention on the Rights of Persons with Disabilities, together with CEDAW, which is the Convention on the Elimination of All Forms of Discrimination. We do not make reference to international customary law in particular, but we do so mention treaty law. Now, the applicant also mentioned that there were no available local remedies with regards to there were actually available local remedies with regards to this claim. But the applicant continued to submit that no local remedies were indeed tenable in this matter. This is because a remedy is available if it cannot be pursued without hindrances. And in this case, as was noted in the Jawara versus the Gambia case, there were various hindrances that stopped local remedies from being fulfilled. The respondents mentioned that the application was, of course, filed out of time, but in the case of the Prohibit versus the Gambia, it was stated that the court is not necessarily bound by the rules of procedure. The court should not be necessarily bound by the rules of procedure where it is at the expense of justice. Now, the court should also take judicial notice of the fact that the respondent mentioned the case of the Law Society of Zimbabwe versus Tanzania, but this is misleading as the case is actually, in fact, the Tanganyika Law Society versus Tanzania. Now, in stating the claims of the respondent with regards to the second speaker, the exclusion of men that they mentioned actually discriminates against these particular men in question. And this is noted with regards to Article 2 of the Convention on the Right of People with Persons with Disability. It seeks to promote the equality of all persons. Therefore, the exclusion of men takes away from the enjoyment of these particular rights. We also thank the second speaker for mentioning the link between the right to life and the enjoyment of other rights, because this speaks to the quality of life for which the applicant has made its case. Now, the respondent mentioned the differential treatment, of course, as being provided for in law and being justiciable. But of course, this Convention on the Rights of Persons with Disabilities does not make provision for such differentiated treatment. And of course, quoting Article 18 of the Vienna Convention on the Law of Treaties, and in keeping with the Convention on the Rights of Persons with Disabilities, it states that when interpreting any treaty, the court should take during account of the object and purpose of the treaty in question. And in this case, for the court to effect a differential treatment of these individuals will be tantamount to a violation of international human rights law. Now, the second speaker also mentioned a nexus, that there is no nexus between the actions of the nurse and the state in the present case of Schmitter. But the applicant then submits to buttress this point that the government has a duty to ensure that all health professionals, such as nurses, be informed by their bioethics and to sound medical teaching that is not influenced by superstition. This is confirmed in Article 25D, Article 25D of the African Charter, which places an obligation on states to require health professionals to provide care of the same quality to persons with disabilities as to others, raising awareness of the human rights, dignity, autonomy, and needs of persons with disabilities through training and promulgation of ethical standards for both private and public healthcare. Thus, the refusal of the nurse to treat Schmitter is deplorable and constitutes a violation of Schmitter's access to health. These will be the rebuttals of that.
Council, what are the requirements for state attribution at law?
Thank you, Excellency. Now, the draft article in state responsibility states that for any action to be attributed to the state, it must have been done by the state in question, and such conduct should violate international obligation.
And are these requirements met on the facts of your case?
Thank you, Excellency. Now, these requirements are not expressly mentioned, but taking into account the fact that such attribution can be taken into account with regards to Article 25 paragraph D, for which we have already mentioned. It places an obligation on the states to train its health personnel, which are of course covered and guaranteed within the law of health within that particular country, and therefore such action can be attributed to the state because of the state's role in regulating the practices of medical professionals. Thank you, Your Excellency.
The court will adjourn for a brief moment. All rise. Thank you, ladies and gentlemen. We shall go for a lunch break, which will be strictly 30 minutes, and then we'll come back after lunch for the results of our preliminaries, and then find out who's proceeding to the final round.